Directive tutorial. What you're seeing in front of you is the document that you can download from regnumlegal.com, and it is the Advanced Directive for a married couple. It's exactly the same as the Advanced Directive for a single person. The only difference is that here where it says spouse 1 and spouse 2, it's just going to say your name. So I'm going to use the married person's template. And then just know if you're single, yours is going to look exactly the same, except you're going to have only one name to fill in. So last time, if you followed along on the Living Trust tutorial, we looked at the estate of Jack and Jill Doe. And they developed their living trust, and now they're going to be doing a healthcare directive, and I'm going to walk you through this process. The Advanced Healthcare Directive is probably one of the most important estate planning documents you can add to your estate plan. And the reason is because most of your estate planning documents are going to be used after you die. For example, your living trust really doesn't come into play until your death. And your pour over will doesn't come into play or even become really effective until your death. Your power of attorney might come into play if you're incapacitated, but in reality, the Advanced Healthcare Directive is something that everyone needs, because at some point, everyone will die and everyone will have an opinion about the kinds of treatment that they want and don't want at or near the time of their death. So after you've downloaded the Advanced Healthcare Directive, the first thing you're going to do, as you see here, is you're going to have to fill in your name. Now, here it says spouse 1 or spouse 2. The Advanced Healthcare Directive is only for one person. Okay, that's why, the single person or the married person, it's going to be the same. The reason I put spouse 1 or spouse 2 here is because what we want to do is whoever's going to be spouse 1, it'll be spouse 1's healthcare directive, and they're going to designate the other spouse as the initial agent. So here, spouse 1 was Jack Doe. So we'd put Jack Doe. We don't need spouse 2. And then he needs his address, and I believe he was, right, before New Home Lane, California. Hereby designate, and now, again, it's the opposite. This was spouse 1 or spouse 2 right here, and we went with spouse 1, so now we go with spouse 2. If up here you went with spouse 2, you'd go with spouse 1. All right, so you want now, Jack wants Jill to be his agent, live at the same address. So we can just copy that and paste it. And Jill's got a very, very easy phone number. There you go. There's Jill's phone number. It looks unlike any phone number I've ever seen in my life, but Jill's lucky apparently. All right, so that's the initial designation. If you're single, you're going to have your name and then who you're going to appoint as your agent initially. Now, just like your living trust where you had an initial trustee and then a successor trustee, the Advanced Healthcare Directive is the same. You have an initial agent, and in this case, it's Jill Doe, but it could be anyone you want. And then the second thing you have is the alternative agents. Now, the most common thing to do is just put whoever your successor trustees are, put them as the alternate agents. And this just helps keep continuity. But I would suggest really giving some thought here about who your agents should be, because the considerations for having a really good trustee are different from the considerations of having a really good healthcare agent. And I'll give you an example from my own personal life. Before I was married, I had a healthcare directive, and the directive named my dad as the agent. And my mom got a little bit offended because my mom is much more inquisitive. She's much more apt to ask the appropriate questions for medical treatment and things like that. But I chose my dad because I thought that if it came down to it, if I got into some kind of accident and He had to make the decision to pull the plug. I thought that he could make that decision a lot easier than my mom. So I put him as the agent essentially to spare my mom from having to make that decision if it ever needed to be made. One thing you need to consider here with the agents is who's going to firstly be able to carry it out, both someone close to you in relationship that you trust, but also close to you in terms of somebody who could be at the hospital quickly. So if you've got relatives in another country, I might not put them as the agent because maybe they can't get here to make those kinds of decisions. Anyway, but Jack and Jill are going to keep their trustees here because both Bill, Bob, and Sue are really, really trustworthy. So first agent, they're going to go with Bob. All right. We're just going to keep the same names. The alternate agent, that's going to be pseudo. And again, we're just copying and pasting. You guys would put your own address in there and you'd fill it all in. Don't need to do that. Third alternate agent, here, it's not a trustee, so they're actually going to add Bill, even though he's a deadbeat. They're going to put him on there. And that's how it goes. Okay. So you don't have to have 3 alternate agents. If you only want one, you could just have one. You just delete it, right? You just have one alternate. You can have just 2 alternates. You can have a 4th one and add a 4th if you want. But I would recommend at least having one alternate agent. But you don't have to. There's nothing in the law that requires you to have alternate agents. It's just helpful to have them just in case. All right, nomination of conservator of the person and estate. All right, what does this mean? A conservator of the person is somebody who's going to be controlling where the conservatee, that means the person who's under a conservatorship, where that conservatee lives, whether they can get married, where they eat, where they go, that kind of thing. The conservator of the estate means the person who's going to be making financial decisions for the conservatee, the person who's under a conservatorship. Now, as it relates to this, I really recommend if you're going to nominate a conservator of the person and estate, I would really recommend choosing the same person as your trustees, because you want someone, if you become incapacitated, the trust will become irrevocable. The trustees will have to manage your estate. And so you want whoever is going to be a conservator of the estate to be the same person who's managing the trust that the estate's in. So you would put that information here. In this case, they're going to put the same. They're going to put Bob Doe as the nominee, and the alternate nominee is going to be, well, let me say this. If you're married, let me back up. If you're married, you want to put your spouse here. So actually, it's going to be Jill Doe, and Jill's healthcare directive will have Jack on there because we want the spouses to be the first conservators. As alternates, we want the trustees, so we'll have Bob Doe. Second alternate, we'll have Jill. Excuse me, we'll have Sue. And then you'll fill in the address and telephone numbers as appropriate. All right. The next portions of this, you're not going to have to do too much more filling in. You're going to have to do a lot more reading and a lot more customizing. Unlike the living trust section, which is pretty much fill in the blanks and then you're good to go, this has a lot of different alternatives that you need to carefully read. And so these brackets in green are your instructions, okay? And so you're going to want to pay attention here. So here it says, general statement of authority granted. This is the authority that you're granting your agents, the people you listed up here. So the authority you're granting to Jill, and then the successors or the alternate agents, Bob, Sue, and Bill. This is the authority you're granting. And you have a couple of options. And you'll see here, it says add one of the following. One of the following. You can't have more than one of these alternatives. So you just pick one, okay? Don't just delete the green and leave everything there. Just pick one, all right? So what you're going to want to do when you're customizing this for yourself, delete these green sections, right? And pick the one alternative you like the best, right? There's alternative 1, 2, and 3, all right? And the difference is that this is a general The first alternative is a general sort of, we give them power to make healthcare decisions, etc. Alternative 2 is much broader than the first option. And so if you want to authorize a much broader scope of authority, pick option 2. And then, if you can imagine it even further, we've got a much broader authority in alternative 3 and I'm going to put here on the screen and. Okay, it's broader authority and it's immediately effective. If you can see that, immediately effective. So if you want your healthcare directive to be immediately effective, this is the one you want. Now, there's a lot of reasons why you would want a healthcare directive to become immediately effective. One of the biggest is that it means that as soon as you become incapacitated or unable to make a medical decision for yourself, the person who you've named as an agent can immediately start making the decisions. If it's not immediately effective, then you're going to need some sort of determination that you cannot make decisions for yourself. And oftentimes that's going to be apparent. You're in a coma, you've developed dementia, you are, temporarily or permanently brain damaged. And so it'll be really apparent whether or not you can make decisions for yourself. But nevertheless, it's still going to take a little bit of time and possibly court intervention in order to be able to get the authority to start making medical decisions. And so oftentimes I prefer, my own personal preference is an immediately effective directive. And here's why. One, I don't want the trouble of having to verify that I am incapacitated. The second part is that, as long as you can make your own healthcare decisions, your agent doesn't get to make any of the decisions. The hospitals aren't, if you have an immediately effective healthcare directive, it's not going to mean that whoever you name is all of a sudden in charge of your prescriptions and has to go with you to all appointments and stuff. The hospitals are always going to defer to your own wishes to the extent you're able to communicate them, even if you have a healthcare directive that's immediately effective. So for me, the benefits of an immediately effective healthcare directive outweigh the possible risks. That's not always true, like for a financial power of attorney, but at least for a healthcare power of attorney, I kind of like it. But you can have a different opinion. In this case, I'm just going to pick the third option because that's the one I like personally the best. All right, so then that's it. So that's it for the customizing of section 4 here, the statement of authority granted. And this just, again, it goes over the authority that you're giving to the agent. Now, number 5 is important because it discusses when the agent's authority becomes effective. Now, remember, when we were discussing these alternatives up here in 4, we ultimately picked the one that said it's immediately effective. Right here it says, my agent's authority shall take effect immediately. You'll see that right there, immediately, on my signing the directive. Now, if you didn't pick that, or even if you did, you've got to customize number 5, and it should match. In other words, you don't want an inconsistency. You don't want to pick the third option for number 4 and have it immediately effective, but then only have A, and then pick option A here where it says it's effective when my primary care physician determines that I'm unable to make my own healthcare decisions. You want it consistent. So if you've picked alternative 3, pick alternative 3 here as well. If you've picked alternative 1, pick alternative 1. Or you could pick alternative 2. The difference between 1 and 2 is here you're relying on just your primary care physician. So if your primary care physician just says, hey, unable to make own healthcare decisions, now your agent can start acting, then that's fine. If you want a little bit more protection because maybe you're a little more cautious, you can choose alternative 2, which is not only your primary care physician, right here you'll see, but it's also another person. Okay, and so I've had some clients who are really, really concerned for religious reasons about maybe being euthanized or something like that, and so they might put in their pastor or they'll put in someone they trust who really knows their wishes and understandings, maybe from an ethical point of view or a religious point of view. And that way, it's not just the doctor, but it's another person saying, yeah, this person can't make their own healthcare decisions. But it's totally up to you. We're going to keep it consistent. Again, guys, you have to customize it. Only choose one of these alternatives and then delete the rest, including the green brackets. So we're going to choose 3 again, and I'm just going to delete it. All right. Then we have, if applicable, add the following option, capacity determination. Now, if you chose option 1 or option 2, then you need to do this capacity determination. All right. In other words, you've got to designate who your primary care physician is. So if your agent's authority becomes effective when a primary care physician determines that you're unable to make your decisions, you've got to tell the hospital or whoever is dealing with you who that primary care physician is. In this case, we want it to take effect immediately, so we're not going to add this option. But if you want a primary care physician, you'll have to fill that out. Instructions for healthcare. This is the most important part. This is probably why you guys are doing a healthcare directive, because you want to provide instructions. Okay, you've really got 2 alternatives for healthcare instructions. And we'll see here, alternative 1 and alternative 2. Alternative 1's really simple, prolong life. And that's basically, if you want your life to be prolonged at all costs, even if there's little chance of recovery, even if the benefits outweigh the burdens, even if it's going to be really expensive, if your wish is just to stay along as live as possible, you have that option. Choose alternative 1, prolong life. If, however, you want to choose, I don't want my life unnecessarily prolonged, you've got alternative 2, do not prolong life. Okay, and then you've got a lot of other hard decisions to make. It's really easy if you want to prolong life. It's just this little tiny paragraph. But if you don't want to prolong life, you've got a little bit more work to do. And frankly, I don't think I've ever had a healthcare directive I've designed for a client that wanted to prolong their life. Nearly everyone that I've worked with does not want to prolong their life, but they've got some customizing that they have to do in there. So Jack and Jill are going to be the same. They're going to just choose do not prolong life, and then they're going to make some other choices. All right. I always tell people, if you don't want to be starved or dehydrated to death, then delete this and put in here, there's going to be an option that says, despite what I say up here, I still want nutrition and hydration, right? But I don't want to be resuscitated. I don't want to be et cetera. But, I can't tell you the language you need to have. I'm just highlighting that this is a very key and oftentimes touchy portion of the healthcare directive. So if you want it exactly as this is written, just, delete this bracket. In this case, we're going to have Jack and Jill just keep it the way it is. They're not going to put customizations in there. And if you are that way, keep that bracket and make it go back to black and go here. And maybe you leave it bolded so that it's really clear that that's what you want. All right, so that was alternative 1. You also have another alternative to not prolong life, and it's a little bit more specific. Okay, I actually like this better because it allows you to customize it a little more. And so despite the fact that, despite the fact that we have this, we're going to keep this optional addition. Okay, so you don't necessarily delete this portion if you wanted option 2, but you can add this other thing. So I'm going to add this on there because I think it's valuable. I think Jack and Jill like it. All right. So this communicates that you want to make your decisions as long as you're able to. And if you're incapacitated, then your agent, the person you list on here, up here way at the top, these people, right? Your agents will have the authority to do all this within the context of your personal values, right? So they're going to make decisions in the context of your personal values, and this is communicating your personal value. So I would say add or delete these as necessary. So if you agree with this, but you don't agree with this, then, maybe you have no religious beliefs, delete it. Maybe you have specific religious beliefs, and we've got specific templates for different religions. I think we've got Catholic, Jehovah's Witness, Christian Scientist, and Jewish healthcare directive options that have more specific terms. But maybe, you're a member of a different faith that's not on there, and you want to put, I want my religious beliefs to be honored. I am a Methodist. Right, there you go. And then so your agent's going to look to the Methodist faith and theology to determine is something right or wrong, right? And it'll also help courts in case they have to decide what's right or wrong. If you don't have religious beliefs, just delete it. And if these are things you want, keep them. If not, delete it. And if you want to add a sixth, you can add a sixth, and you can say, I want the ordinary. There you go. I want the ordinary means of preserving life provided at all times. What does that mean? That means I want food, I want water, I want, to be ambulated. Those are the ordinary means of preserving life, right? Everybody they need fresh air, they need food, and they need water. So you can give them oxygen, you can give them food, you can give them water, but everything else is extraordinary, right? Breathing tubes are extraordinary means of preserving life. So you can put that in there if you want. It just depends, whatever is your preference. In this case, we'll just keep it as it is. This alternative one, right, where it says continue nutrition and hydration, this option up here, if you've left this in, then you don't want this option, okay, because it's inconsistent. Okay, if you want this option, you have to delete this part, right? In our case, Jack and Jill want to keep that in, so they're going to continue, but they're going to delete that part because they don't want that. Okay. The other thing is that Jack and Jill have the option to expand on what this means. Okay, and that's what this is intended to do here. But if I remain in a coma for X number of days, et cetera, et cetera. So what you could do there is you could keep this in, okay, and then add in, I want food and water at all times, but if I remain in a coma for 10 days, right, my agent's authorized to withdraw the nutrition and hydration. Okay. And this is key too, as long as they're not necessary for comfort or alleviation of pain. So, if a thing you're concerned about is, what happens if they remove my nutrition and hydration and I starve to death, and I'm aware I'm starving to death and I suffer pain from it. This kind of puts a stop to that. So one of the factors here would have to be is, do you have enough brain function to actually experience pain or comfort, or are you completely gone such that pain and comfort are beyond anything that your brain can comprehend? That's what that's in reference to. But again, Jack and Jill, they don't want any of this stuff. We're just going to delete it, and you can too if that's what you want. Now, Jack and Jill do like alternative 2, right? No nutrition and hydration except for treatment of temporary condition. Here you go. So if you don't want, artificial nutrition and hydration up here in this paragraph, you can clarify that, even though I don't want it, I do want nutrition and hydration if I have a temporary condition, where I can only I can't eat or drink for a short period of time. And then that's okay. The third alternative is the no artificial nutrition and hydration except for my comfort or to alleviate pain. And if that's important to you, keep that in there. Okay. And then you continue on C and D. Jack and Jill are comfortable with alternative 2, and they're going to delete that. And then we'll keep B. We'll have the new B, and we have C and D. All right. And that is section 6. That's your instructions for care. If you have any other instructions, you can add them in here as necessary. 7 is inspection and disclosure of information relating to my physical or mental health. Oftentimes, in order to get a full assessment of your condition, your agent is going to need access or be told information about your medical history. This allows your agent to get that information. Okay, so it allows your agents to request, review, and receive any information, verbal or written, regarding your physical or mental health, and this will help your agent to make a really good decision. Signing documents, waivers, and releases. All right, here's another part where you have to have some sort of customization. Again, you can only have one. Okay. Alternative one, specific language. So if you want a specific language about signing documents, waivers, and releases, you want this. If you just want general language, take alternative two. And as a lawyer, I kind of like the more specific language, just so there's no question that you want all of these your agent to be authorized to sign all of these documents and any other waiver or release from liability. So it's broad. It's as broad as this, but has specific language in there that might help the enforceability of your healthcare directive. So I like that one, but you could choose whichever one you want. Visitation. Okay, here's another one that's a personal preference. I can't really give you, there's no real legal right or wrong. If you want to delete visitation altogether, you can. If it's not a concern to you, just delete it. If it is a concern to you, keep going. There's a couple of alternatives you have to add. And the first alternative is that your agent shall restrict visitation. And it basically tells your agent that if the agent decides that a visitor is distressing or interfering with your treatment, then the agent can kick that person out or prevent them from visiting. And that's what alternative one says. So the difference between alternative one and alternative two is that alternative two really applies if there's just a single or maybe one or two people that you are worried about that might cause a ruckus while you're in the hospital. And if that's the case, then specifically say that they're not allowed to visit you. Okay. So you'd say, here, maybe Jack and Jill, they don't want Bill to show up drunk, right? Bill's going to show up. Bill's wife. Bill's married to a gal named Sally. Sally Doe. She's an alcoholic. They don't want the daughter-in-law to visit them because she's always drama. So they'd put Sally and they'd put my daughter-in-law. There you go. That's what they would do if they wanted that. I prefer alternative one. You don't have to agree with me, but if I were worried about a very, very specific person, I might keep alternative one, and I might, also keep alternative two and keep both, and just specifically say, hey, he can kick anyone out that's distressing me. And in particular, I don't want her. So you might be able to have both if you want. All right, donations of organs at death. There's really only two options. And the first option is sort of divided into two parts. So the first option is you're okay with your agent donating your organs, tissues, or parts, or some of your organs, tissues, or parts. And then the second option is you don't want your agent donating any of your organs, tissues, or parts. Okay. If you want your agent to be able to donate your organs, tissues, or parts, then you've got two options. And here's alternative one and alternative two. Alternative one is the broadest. Any organs, it says. So on your death, your agent can donate any of your organs, tissues, or parts. And then you have to choose that the purpose for which the parts are going to be used. So they can be used for transplant, they can be used for therapy, they can be used for research, or they can be used for education. If you don't really care, just keep them all in there. If you want one and not the other, then this says delete any choices you don't want. So maybe you only want transplant and therapy, but not research or education because you don't want to be, a guinea pig at medical school and having students practice autopsies on you or something. Maybe that's something important to you. Maybe you just want transplant. Maybe you're okay with all of it. I don't know. But you would just have to delete the ones you want and keep the ones you do want. The second alternative is just specific organs. and it says that your agent is authorized to give the following organs, tissues, or parts only. So if there's certain organs that you know you're okay with, but you want to keep everything else, then list it. Alternatively, I've had a client that has just said, my agent can donate any organs except for my brain and my heart, but everything else, go ahead and donate it. My eyes, my skin, my whatever else, go ahead and donate those, but not my heart and not my brain. And you could do that too. You can customize these however you want. And then again, you've got to pick the purposes. You just delete the ones you don't want. In this case, Jack and Jill don't want to donate any of their organs, and so they'll just keep option 3, which says, on my death, my agent not authorized to donate organs. Disposition of remains. On my death, my agent is authorized to dispose my remains as follows. And here's where you would insert your instructions, right? And it says, as an example, burial, funeral. If you have a specific wish about how you want your remains to be disposed, put it in there. Some people, have religious customs that have to be followed with regard to their body. Some religions don't allow cremation. Some religions don't allow cremation, but don't allow scattering the ashes. So, if you have very specific wishes about how you want your body to be handled, put it in here. And there's no sort of form template for you to follow. It's really just start typing. Type whatever you want. In this case, Jack wants to be buried. I want in I want to be buried in a cemetery in California. All right, great. Um, and I've had clients make very specific um, instructions. Some clients, and if you are one of them that already have funeral plans, that already have a plot, that have already purchased sort of a funeral package, put that information in here and say, I want to be buried in Shady Acre Cemetery. I've already got the plot number, and here's my account, and here's all this information. Stick it in there. All right. Next, autopsy. This says that your agent is authorized to grant the power to authorize an autopsy. If you care one way or the other, stick it in here. Um, and it's been 50-50 about what client preferences are, at least in my experience. So just put whatever your wish is, whether you care one way or the other. Last bit of customizing you need to do, you need to put the date. Let's just go March, 23rd, whenever the date is that you're signing, 2020 at Fake City. That's where they were living, right? Fake City, California. Name, and remember to put your name in here. It was Jack Doe. And if this happens to you where the certificate of acknowledgement kind of goes up, I just move it down to the next page. I like keeping it all on one page. All right, certificate of acknowledgement. You're just going to have a few little customizations here. Name of county, whatever it is. I think we said it was Orange County last time. For date, fill in the date that you're going to go to the notary. If you know when you're going to go to the notary, in other words, if you're going to the notary the same time it's executed, if you've called a mobile notary to come to your house and help you, then type in the date the notary is coming. If you really don't know when you're able to get to a notary, because maybe you're in quarantine during the COVID pandemic, then just put an underscore here on blank, and the notary will fill that out. Again, here, the notary is going to fill that out himself or herself. You don't need to worry about that. All right, name, you're going to want to put your name. And then if you want, you can add, the proper pronouns here. If you leave it, the notary will take care of it. You don't need to customize it unless you want, but this is something you can also customize. All right, and again, if this happens to you where the statement of witnesses kind of comes up on you, then I just move it down so that it's all on one page. Now, the statement of witnesses is important because what it tells a hospital is that not only is the Advanced Healthcare Directive valid, but it gives an indication that you or the witness believes you're of sound mind and not under duress or fraud. And you're going to have to put who that witness is, the name and address. And if you don't know, they can just kind of sign it in themselves. And then here's this part where it says at least one witness must also sign the following. You're saying under penalty of perjury that you're not related to the individual executing the Advanced Healthcare Directive by blood, marriage, or adoption. And you're not entitled to any part of the individual's estate. And here's why. This is why this is important. The law is concerned about the possibility of a beneficiary, okay, of a trust, say, becoming a healthcare agent, let's say by fraud, and then withdrawing treatment to hasten the death of the trustee, the trustor of the trust, so that they can get the money faster. And these witnesses kind of provide a safeguard by making them not be the agent up here and making sure that at least one of those witnesses is not related to you by blood, marriage, or adoption. It prevents the type of fraud that sometimes exists when greedy beneficiaries try to, let's just say, hasten the death of their mom or dad or uncle or somebody else to get at the estate. So that's why that's there, and that's why that's important. So when you're picking the witnesses, make sure you pick someone who is not related to you by blood, marriage, or adoption. Go to your neighbor, get your neighbor to sign it. If you're at the post office, just maybe you call someone over and have them witness it. Or call up a friend and have them witness it. But it shouldn't be blood, marriage, or adoption. And that is it. This is the most important document that you're going to have in your estate planning arsenal because it deals with very, very sensitive, right here, instructions for healthcare. Again, spend time with this document. Really make sure that this document expresses your wishes, expresses your beliefs, and expresses your values right here. Following personal values. If you have a religion, state it on there. Again, I can't stress this enough. Remember Terri Schiavo. Had she had a document that stated her personal wishes and desires, it would have saved her family a lot of money in legal fees. It potentially, if her parents are right, that she would not have wanted her hydration withdrawn, it potentially would have saved her life. And number three, it would have prevented the type of contentious family squabbles that we saw. Now, I'm not making light of the situation that the Schiavo family went through, but the reality is that the parents of Terri Schiavo were fighting with the husband of Terri Schiavo, and had there just been a clear directive, they could have avoided a lot of that tension, a lot of those fights, and a lot of that sort of heartache that made saying goodbye to Terri that much harder. So do your family, do yourself a favor, spend time on this document and get it right so that if the time comes when somebody ever has to make the decision to withdraw life-sustaining treatment from you, they can do it knowing not only did you want it, but that you were specifically giving the instruction to do it. So it's as if you are giving the instruction and not a family member, which can prevent a lot of fights, a lot of resentment, and a lot of problems down the road. All right, guys, that's it for this tutorial. I hope you liked it. I hope it was easy to follow. If you have any questions, go ahead and email me. I'll put my email address in the description below. I'll also put a link to the resources in the description below, just in case you are following this on YouTube and want to know where to access the documents, or maybe you've forgotten where to access the documents. I'll put a link in the description below. Guys, thank you so much. Please stay tuned for more tutorials on how to complete your estate plan, and we'll see you next time.